Welcome to the House Judiciary Committee. That's Wednesday morning, May 14th. We have a few items to look at this morning, and we're going to start with S12, the ceiling bill. So yesterday, there's really a couple issues to talk about. But yesterday we had testimony from Marshall Hall, and he raised a couple of issues. The document I put in front of you, I think addresses one of the issues, which is that sometimes a person can act pro se, can be their own attorney in a criminal case, and we want to make it clear that they can also use a sealed record. That's what this one does. The other issue was as far as what use these documents could be made of. And I'll use the specific example that raised concern for Marshall, and that is if they provide a document, a sealed document to a lay witness, and does that lay witness have any obligation to not disclose the document? So I did work on some language to try to address that, but I've also heard from and I don't know that we need to address that. I think the example is kind of a little far-fetched and unlikely that somebody's going to use a document that would either have been, if it was a felony record, probably at least 7 years old, and how relevant would that be? And it just doesn't. I'm not convinced we do need to do anything. If the rest of the committee disagrees, I can propose some language which I've run by Judge Zone, who says from his perspective it's fine, but the Department of State's attorneys do not think it's fine. And the main thing is that they don't think it's needed because the rules of professional conduct would cover an attorney's responsibility for handling confidential materials. And that would include making sure that there are precautions if they're using it with a lay witness. They would need to make sure that they either don't email it to them or they just show it to them and keep the copy, etc. So, but I want to hear where other people are with that. So yeah.
Well, the first thing that just comes to mind are like medical records and how they are treated amongst lawyers who are representing and prosecuting. Do defense attorneys need a medical release?
Yes.
Prosecutors would need it. They would have to subpoena or summon the record.
To use it in court or to get access to it at all. Right. So
where does that make it more complicated? I'm just thinking that they're kind of similar in a way. They're confidential records. To use openly or publicly, you need authorization from the person.
Sure. So where does that?
Well, you wouldn't if you were prosecuting somebody, would you? They're going to get it directly from the healthcare facility.
Is your question, or is your point about using it in court, or is it about actually being able to access the record? To access the record, you're going to need an authorization from the person.
Yeah.
As far as using it in court, though?
Well, when you get it, I don't think you need it. To say the state would summons to subpoena it or inquest on a medical facility and use it for the charge, correct? It's kind of like a predicate offense now. That makes sense?
Yes, I guess, well, yeah, except that.
You know what I mean?
I
Totally in reverse.
No, I know what you mean, but where does that leave you with this issue of putting further restrictions on the use by in some way?
I don't.
Right. So Karen.
Yeah, I talked myself in a circle. I don't think you need to.
Right. That's kind of where I am. That's
For me, I'm fine with not adding additional language. I feel like the piece of the professional conduct covers it. And the other piece is that for me, a primary goal of this is that folks aren't making decisions around housing, education, and work on this, so it's fine. And the reality that information is likely still out on the web and other sources of it. So I just feel like as long as attorneys are following their professional code of conduct, it's covered.
And why we're saving the records to begin with? To be able to use them for whichever purpose we need. That they remain.
Yeah, so I think, are we on the same page?
Oh. Or the defense.
Like, we're
Yeah.
further from.
Like, so, and we're in agreement, we don't need language, is that? I don't know.
Yeah,
That's what the bill's all about.
Did the state's attorney cite which rule that they are relying on?
You like it or not?
I don't think we need.
They did not.
What?
Nice.
Every time I talk about it, I go right around the circle.
Did you do it backwards?
No, I don't know. I'm clockwise, man.
So anybody else want to weigh in on that? Anybody have a different view that we put the language in it? Yeah.
And then my only question was, so you didn't like the more elegant sort of
I just think
defendant?
No,
I know.
I didn't think that it was quite fair as far as how Michelle.
How it was in that draft.
Yeah, I mean, I think this is, it's more wordy, less elegant, but also, I think, clear.
Why couldn't it be a civil defendant?
We don't want to open up don't say use of criminal records in civil cases. That would be, I think it's got too far, I think.
So can I ask the question?
Yes,
Can you tell, so there was a different version of this language proposed, right? That
Yes.
Wasn't quite as,
all it said was a defendant may use a sealed criminal history record, period.
Okay.
Is what Michelle initially talked about.
so, and this is something that's making explicitly clear a fact that is already pretty clear in the bill, right? Or is that?
No, I think the part is just the pro se,
Yeah.
because criminal defendants
Yeah,
could represent themselves, and I don't think it was clear. that
Okay.
They would have access to sealed records.
that's the part that I'm focused on, because I don't know, I have a fondness or something, like a fondness for pro se litigants and wanting them to have full access to, their,
Although they really shouldn't defend themselves.
well, I mean, it's true, but all kinds of.
That's generally a really bad idea.
It is a terrible idea, and there may be some other issues if someone makes that choice, there might be some other things happening. But I don't know, generally, I want them to know that they have.
Let's make it explicit.
I would think that they would disclose their own record if they, knew it was important.
Yeah, so I think,
Whether they should or not.
I'm not gonna die on the hill of this language, but I'm just curious about being a new legislator and legislative intent. So like, there's language all over the statutes around defendant. And we never spell out defense attorney versus pro se litigant, or pro se defendant ever. I mean, maybe there are places, but I don't see very many. And so like in this one instance, we're like making it clear that we're talking about both.
We can check with Michelle on that still.
Yeah. I'm just wondering, like, does that mean that like someone would then could go to like a different statute and be like, well, they didn't spell out pro se litigant here, so they're saying defense attorney.
Right.
Because they spelled it out here.
Right, yeah, no, you make a good point. We should double check with Michelle, but part of my issue was defense attorney may use a sealed criminal history, or I mean, a defendant may use a sealed criminal history record. It didn't really say, or at least how Michelle had it. It didn't say for what. It didn't bring limitations on it. I guess a defendant may use a sealed criminal history record to defend
In
the
the
defendant.
course of
in the
their.
course of their case. Yeah, of course of defending their.
Yeah, but we also have to make it a criminal defendant. You need to make that clear.
Well, this.
Let me check. I'm planning on having the vote on this after
Oh.
the floor today.
Okay.
Because Coach probably is not going to be here until after the floor. It's supposed to be a very short floor. So we should be able to do that. Yes, sir.
I know some defendants that are pretty proud of what they've done and will probably be mad if you field it.
Well, it's up to them to get it.
Well, that's why I think people should petition to have something sealed too. If you don't care enough about making it go away, then. But.
Well, but this thing sets them up. They have to petition.
Yes, I know.
There's nothing automatic in
Yeah,
there.
I know.
So, anything else on this part that we can, and does anybody disagree that we don't need that additional language? All right, so the other issue was with respect to embezzlement that Jack brought up on Friday, or Thursday, I don't remember when it was, Friday. And what's the latest on where you are with that, Jack?
I mean, I would love to see it removed. But if the compromise is moving it to 10 years, I can live with that.
So I guess I'll definitely, we want to hear from everybody on this. I just want to give a little bit of background on why that is there and why it's still there. Sorry to give you a little history, but actually in 21, the Joint Justice Oversight was charged with looking at sealing and expungement and automatic sealing. And what that led to was a bill, it's 534 in 22 that passed both the House and the Senate, and it had all the property crimes that we have in here as well as the drug crimes. But it was all adding those for expungement. So those documents would be deleted, which caused the governor to veto that bill. We did not try to override that veto. And he explained in his veto message why, and he doesn't want to see things expunged. He did not point out particular the financial crimes. He did not point those out as an issue in that. But he proposed and pushed for universal sealing is what they called it. And that's what we started doing last session. And we included the property crimes as well. It passed out of the House. Nobody except, again, I think Chris Delia last year and the biennium before raised that issue, but hasn't provided us the additional evidence really on why 10 years versus 7 years. But also that it's the context of this is a trade-off. This is a trade-off of going to sealing with including all the crimes that right now are being expunged. And the trade-off is that we're going to add more offenses and embezzlement is one of them. So
This one thing that jogged in my memory about is, isn't it? We didn't land at 7 years as an arbitrary number, if I remember right. It had to do with recidivism rates. And it was kind of like the 7 year that people, if they didn't re-offend in 7 years, that recidivism rates show that they're probably not going to. And one thing that kind of gives me a pause about going to 10 years for the embezzlement is, and Chris said it himself, that if I get special treatment, that other people are going to want special treatment and it's going to blow up this bill. And I think we started working on this in 2018, if I remember right. And the reason I think that 2018 is because of the JP Morgan testimony that you found, Barbara.
Right.
And they were fine with the 7 years back in 2018, JP Morgan was. you know, their thing was, you know, everybody deserves their second chance and that type of thing. And with a big financial institution like JP Morgan, not having a problem with it. I mean, I would love to see it all go to 10 years, I guess, if it was going to improve anything as far as recidivism rates go, but it doesn't. So that's the main reason I'd like to stay at 7 years. And, yeah, I mean, we're so close on this bill. This is, for me and for many of us, year 7 of working on expungement and sealing. And, we're on the brink.
Yeah, trying to get to closer to universal sealing. Yeah, exactly.
So I did review the testimony that Nan Gibson provided from JP Morgan Chase and the Policy Center. And if you look at the document that Barbara sent around on Friday, it specifically cites in Nan's testimony, section 19 of the Fair Hiring and Banking Act. And I'm going to quote from the document here, which would expand employment opportunities for those with a previous minor criminal offense without posing risk to safety and soundness. And I agree with that. I don't think embezzlement merits, it's not a small minor infraction as identity theft or fraud or, you know, whatever it might be, a wiring fraud. Embezzlement is a very deliberate act that is really maligning large financial institutions and also defrauding their investors and more importantly, their customers. And as someone who's worked in the banking sector, I think, and again, like I said this to you, Martin, last week, is I've gotten to yes on everything else that's been included. I would feel I mean, granted, I want these removed, but I would feel far more comfortable if we can at least extend it to 10 years. I hear what Tom's saying. I know that this has been a long road. Many of us in the room haven't been on that road as long, but I just think this seems like a really reasonable compromise that I'm bringing to the table. And it doesn't seem outlandish to me. It's three of the litany of financial crimes and real estate related infractions.
So just one other thing as far as timing, and I certainly want to hear where other folks are, is that in reality, you know, it's not just 7 years. It's going to be more like it's going to be over 10 years because you have the offense and then whatever investigation has to lead to a charge. So there's some time there. The way our courts are working, if it's a felony, it's going to take probably at least a year. So you're talking a couple of years before the person is sentenced. My understanding is the average sentences are between 3 and 5 years for embezzlement, for felony embezzlement. And I can put that information that I got from Robin Joy, I can put that online for folks to see. But that's something we looked at, actually what we call the going rates when we were looking at our criminal code revision or rewrite that never passed the Senate a few years ago. But anyway, so you're already talking 7 years before you even get to the point where somebody can, up to 7 years before somebody can even apply for, you know, petition to have the thing expunged. And is somebody going to immediately do that? So there's going to be, so we're talking a lot more years than this 7 years between whenever the offense was committed and you know, the expungement. So adding the 10 years, how much does that add if we're already talking, you know, 14, 15 years or something like that? So
You add the 7 years after investigations in courts and penalties and restitution. So if you get a 3 to 5 year, let's say 3-year sentence, along with a year court case is 4 years, another 7, you're talking 11 years.
right. And then that would seem to me a minimum.
Right.
Yeah.
But usually in a plea deal, a plea agreement, whatever you want to say, don't they usually go and count that as good time served? So it's already there. It's not really extended.
Yeah, it may be. Good point. Yeah, that's a good point.
Yeah, I can count that time.
They do, right?
Depends.
Yeah.
It depends if the person is being held.
That,
And I don't know how many people are.
if they're held, they get credit.
So
There's still gonna be probation and all that.
for embezzlement, people are generally getting, you know,
Depends on how
well,
So I'm just a little bit like, where are we on this? I thought we had general agreement on 10 years and now No,
it's been 7 years.
it's
for-
been seven
for-
and it didn't get moved. And Delia was, tell me again where he was? Because I think I heard something different. I thought he wanted 10 years.
For Delia, yes, he wanted to either have an exception to eliminate a whole bunch of offenses from being sealable or 10 years.
And he also said he understands that giving special considerations are tough because of what the ramifications could be throughout the whole bill and every industry that's covered in it.
So, Ian and then Zach.
I think one element to add to put into this discussion is that the petition isn't automatic, right? So the court's going to look at the underlying charge, what was actually pled to, their time on supervision, and then make a determination as to whether sealing the record is in the interest of justice or not. And I think that there is probably a number of crimes or types of fact pattern crimes that fall between the minor offense and major offense that do get sealed, which you would be concerned about in your point. But I think it's important to note that really major offenses, there's probably going to be a pretty compelling argument made by the prosecutor that it's not in the interest of justice for it to be sealed for the very reasons that you've identified, and it won't. And so I think that that's one check that hasn't been sort of in the conversation that I think is important to note, especially for like really serious embezzlement charges. And the reason I bring it up is because these charges, they have such a variety of things that you could be, like the facts that you could get charged on this. So there are people who might be charged with embezzlement and it's actually a very minor, it's not a major crime, right? Because what you could be charged with could be a lot of different things. So I just think it's important to sort of like look at this holistically at all the different ways that somebody could get discharged and what they would be sitting with 10 years later.
I'm sorry, yeah, Zach, I forgot. Go ahead.
I just think, and I take Ian's point. The thing that I just kind of, to put a bow on this and bring it full circle, is I think the idea that we're misrepresenting what JP Morgan, when they're talking about any kind of, the fair chance banking or any kind of any investigation into background and making sure that people have the opportunity to be employed by the financial services industry, and they're talking about minor crimes and infractions, they're not talking about embezzlement. So I think the misrepresenting of that fact by anyone in this room, it doesn't sit right with me. Because I can tell you that like any reputable firm who is hiring a embezzler or someone who's been convicted of that, I mean, it just doesn't make sense to me. I mean, like I couldn't even trade stocks that were traded on my own exchange, let alone if I was charged with embezzlement. So as someone who's actually been a practitioner of this, it just doesn't sit right with me. It's creating an environment that's rife for abuse. And again, like I get it. Like we don't want a petty theft or whatever it might be to follow people for the rest of their lives. I'm in full agreement with everyone in the room on that point. I really am. But when you talk about something like this, it's not some minor infraction. It really isn't. Like I don't care what way it's spun or any checks that are in the system. Embezzlement is an intentional act that's defrauding a company, its investors, and its customers. And that's just where I am on it.
Yeah, no, I'm saying, I don't think we can or should rely on the Morgan Stanley.
JP Morgan. Morgan Stanley was
JP
incorrect
Morgan.
last week.
JP Morgan. I don't think we can rely on that for that reason. Also in part because what that testimony was for was automatic expungement, automatic sealing, and we have the checks and balances here that it's not automatic, has to be petitioned, and there's an opportunity to object to it. And so it's apples and oranges in some respect. And so, but I understand where you're coming from as
Yeah,
well. But
I heard my concern.
I would personally not like to see any exceptions for felonies at all. Well, any felony precludes you from having the ability to buy a firearm ever again. That's not accepted. But in the interest of moving forward, I guess at this point, we gotta get to ceiling. So I will.
Back to 7.
That's the only thing on the table. I'd like to see 10.
And 10 is off the table to negotiate. I mean,
Yeah, I
it's-
mean, the testimony that we've had over the years is that 7 is, after 7 years, an individual's no more likely to recidivate as the general population is, as I recall the testimony. And, so.
All right. We could be sitting here a couple of years from now going, oh, we need to check this.
Well, that's what we do. We can check in on things as well. All right, well, let's just think about that for a little bit and yeah, we'll need to make a decision on how to proceed with that this morning, but let's let that settle just for a few minutes and let's turn to H41, which we do need to have a vote this morning on H41.
Just right before we move on, for not adding the additional language in around these, I'm good with it if we can actually see what rule of professional conduct they're using and we can, or that they're relying on, and that we can just like make sure we feel good about it.
Okay. Okay, so over to you.
Yep, okay, so on H41, there's been some questions about, criminal acts being reduced to civil. And in one place on here, yes, it did happen, we changed that, before it got voted out of our committee 11-0, and, the piece that it is in the Senate version, it's section 2, person who buries, entombs, transports, or removes the dead body of a person without a burial transit permit, so to do, or in any other manner, or at any other time or place than as specified in such permit shall be subject to a civil penalty, which we in House Judiciary made the decision to reduce that from a 5-year down to a civil penalty and leave the $1,000 fine in place. And if I recall, one of the reasons for lowering it is one thing is a lot of states don't even have it as a penalty at all, or any type of crime. And one of our worries was, I don't remember if it happened or a fear that it would happen, that a funeral home's permit may run out, and because basically of a clerical error, they could have been charged with a 5-year felony. And another reason that we talked about as far as lowering it is that it is legal for Vermonters to bury the remains of their loved ones as long as they get their their paperwork in order, and we didn't want the same thing to happen to them if basically a clerical error in the permit ran. So and another issue was that people were talking about intentionally burn, mutilate, disfigure, dismember, destroy the dead person of a body being changed to civil. And I mean, it's right in here in the Senate version that it's still a criminal act with the same, even though some language has changed between the House version and the Senate version, the penalties are still the same. The penalty for that is 5 years and $5,000 or both penalty. So from there, those are the only questions that I've heard that people are concerned with. And the big one being the the intentionally burn, mutilate, disfigure thing, being civil and it is not. It covers it in the abuse of dead body of a person under 3761A. A covers the acts, and if you go down to D, it has the penalty for it, which is the same penalty that we had in our bill that we passed out.
The original burial transport penalty was 5 years or $1,000 or both, correct?
Correct.
And you just struck the 5 year on the burial transport part.
Right,
the
yeah,
rest-
we did.
Right,
Yeah,
and
we
the
did.
rest is all a new violation, correct?
Yes,
The desecration, maltreatment,
yes.
and what's the minimum on that?
For the without legal authorization, burn, mutilate, disfigure is 5 years, 5,000.
What if it's there's an aggravated one too, right?
Yeah, 15 years, 10,000. Or B and C, which gets into avoiding apprehension, prosecution, conviction. And C has got to do with the sexual acts upon a dead person.
Thank you. I don't have my glasses.
In the bag.
So the original intent of this bill, how this all started out was over the mutilation and all that gory, horrific stuff that happened with that woman up there. We still have got that in the bill. We've more than covered that in this bill to go and do whatever justice we possibly can to take care of that situation. Then there was just another one that I believe months ago or something down in South Royalton, right? Actually, well, up there. Well, it came to, it went to court or something like that, that the stepfather or something like that, right? But then
This bill won't cover either one of those because it's not in place
at the time,
because the investigation is going on in court cases. So after this is passed, or if this does get passed, any crimes after that
Right.
will be covered.
Right.
And the thing that amazes me the most about the way this all came about with Roberta's daughter Pam is she knew this right from the start.
Right.
And her whole thing was people getting justice down the road, even though she knows that she can't. Right. That to me, I don't know if I'd ever even think of doing that, to take care of somebody else, but.
If somebody medical facility wide were to transport and dispose of, that would be a criminal violation. If they didn't have the permit.
The medical, and I don't know my law well enough, the medical stuff is covered under different laws.
It is, okay. So that I'm just trying to
And that we haven't touched that.
get away from, all right.
Yeah. And I can't explain it.
Right.
I don't know if anybody else can, but I know that Ben had talked about that.
Okay.
More than once. Or maybe we can get an explanation right here unless you're good.
might have one right over there too.
What's that?
You might be able to weigh in on that.
That's right.
Zach, and then we'll have Justin. Go ahead, Zach.
Or, I mean, if maybe Justice Point will be illuminated.
If you could identify yourself for the record, and if you could weigh in on.
Sure, thank you. Jessica Barnard, the Vermont Medical Society. So yes, I believe that those are the sections of law that are in Title VIII under the burial permit pieces and disposal of bodies or other remains. And so nothing in this bill except changing that from a criminal penalty to a civil fine. That's the only thing you're touching in this bill regarding that whole title. I think personally, there's some room to update the language in that title elsewhere, but that is a different project for a different day and maybe not even your committee. So so our perspective is that this bill has limited impact, but it does a bit through the changing of the penalty that would apply if any facility is transporting remains.
Limited impact as far as anything to do with the medical.
Correct.
Yeah.
The impact would be changing that from a potential criminal penalty to a civil fine. Otherwise not changing how it works and when it applies and that sort of thing. So we do, just to clarify, we do support that change and thank you for including that in the bill.
Yeah.
So I guess the question that I keep coming back to is what are we trying to account for in moving this from criminal to civil? Like what, because given conversations that I had at the end of last week with legislative council and over the weekend with a lot of members in the body, one of the comments that was made by legislative council themselves is that the final version that we passed out of here did not actually include the civil violation language. It only had fine language. And this was admittedly a mistake made by legislative council in the final run up to the vote out committee. And I think he would say that on the record. I would hope so, because he said that in private conversations with some of us in the, some of us in the room. So I guess the question that I come back to, Chair, is like, what exactly are we trying to solve for? Because from my understanding is that there have been outside forces that were lobbying for this change to be made to allow protections for, their members or those that they provide services for, but abortion is already enshrined in the Vermont Constitution. So I'm just kind of curious where we're trying to go with this.
There, on this section, there was no outside influences. We made that decision in here. I know the outside influences you're talking about. We didn't even have them in here to testify. So they had nothing to do with that change. Ben did, I talked to him also about the difference in language. And he admitted that it was just an omission on his part not to put the civil penalty in the House version. It's what we had agreed to in here, but he didn't put it in the bill, and that's why it's changed in the Senate version, which compared to ours is actually great because there's no crime, I guess you could say, in our version, and it upgrades it to at least a civil penalty in the language. But and again, and maybe Ben can a lot of states don't even have this as a crime. I'm not saying that we should or shouldn't. I'm just saying what a lot of states do or don't. And I'll repeat myself, one thing that we heard was considering funeral homes that they could have been charged with a 5-year felony for basically a clerical error if they moved a body one day after their permit ran out. And it's the same for a citizen who files all the proper permits and licenses to do with a loved one what they want to do, as far as potentially burying them on their property, that they also could have been charged with a 5-year felony or $1,000 fine for, again, basically a clerical error. And I don't remember any other reasons that we decided to change it other than those three. Other states, funeral home and a citizen wanting to do it. But again, there was no outside influences other than witnesses that we heard, and I don't remember hearing any witnesses on this section. Other than maybe, and I don't remember who brought up the potential problem with the funeral home going over by a day, but the outside influences you're talking about had nothing to do with this section at all. No matter
Just an
what
odd
the
question
rumors.
for Ben.
Yeah, so just orient me a little bit, sorry.
H41,
Yep.
and it was brought up, and I think, you know, an omission of the House version not having the civil penalty.
Yeah, and then that was my oversight. That was the understanding of the committee, and I just didn't change fine to civil penalty. And I addressed that with the Senate, and they said, okay.
But we had agreed to that, but
Yes,
you just hadn't put that in?
correct. That was my understanding from all the testimony, is that the Title 18 statute was gonna all be civil. And then everything criminal was gonna be in 13. Which is where our criminal statutes live anyway, or most of them.
Tom, is that?
I do now remember that conversation, this isn't my question, I think, but it may help explain some things. I do
Sure.
remember that conversation because I had serious reservations about people being able to potentially just bury somebody somewhere. And then law enforcement receiving a report about a body somewhere, but there's still a way to now address that issue as far as the person that has done it, and even though they were malintent.
Right.
Like they do something. Well, my question would be, there's a lot of motivations apparently to move a body, a lot of reasons and motivations to move a body. And this regarding funeral homes, if somebody passes away in the middle of the depths of winter and it's not practical to bury somebody, but they move the body from one place to another, do they need to reapply, or what's the usual length of a permit? I mean, because if they're gonna entomb the person and then.
I don't know, to be quite honest. I don't know.
Curious about the.
Yeah.
The logistical issue that the funeral homes could face. I'm just curious.
Yeah, and again, like, these are public health statutes in Title 18, so I could potentially talk to
Well, I'm just
Jen
guessing.
Farby or Katie McClin, because they handle those statutes.
It's decide what it's gonna say. I mean,
I don't know.
I actually, before I ask my question, I'm wondering if I could yield to Rep. Coffin. Because I know that he also shares concerns about this.
Yeah, go ahead and identify yourself for.
Representative Coffin. Just for the record, this is my concern, because I'm looking at the letter that was sent to the memorandum that was sent to senators about H41 amendment, and they had a question presented. You asked whether the language in the Senate Committee on Judiciary's amendment to H41, which creates a new crime of abuse of a dead body or a person, could be interpreted to apply to a person who has a miscarriage or stillbirth and does not dispose of the fetal remains in accordance with 18 VSA Chapter 107, deaths, births, burials, autopsies, and general requirements. The current law has 5-year imprisonment or fines up to $1,000 or both. Okay. So what our amendment does is strike that imprisonment. Okay. Which in my mind, the genesis of this H41 was because remains were disposed of after someone was killed and mutilated, and their body was dumped in the woods. And we're going to make that $1,000 fine.
No.
The dumping of the body, moving a body without a permit. Okay, that $1,000 fine, that's the equivalent of some of the fines for littering. That is the equivalent, that is a lesser fine than if we dig up an endangered plant. That is a lesser fine than if we kill a rattlesnake.
So before you go on, I think there's a misunderstanding. Do you want to explain?
No, go ahead.
Yeah, so-
obviously got something.
Well, that's, so the situation that happened in Franklin County, that. Enosburg. Right, so this bill, if that were to happen again, we can't affect that. Or it happened, But if something like that happened in the future and somebody has mutilated or burned or disfigured the body like they did in that case, that's at least a 5-year felony. So if somebody has something that's not in this bill, but if somebody has moved a body and there's no underlying crime, but all they've done is they haven't, done their permit, we don't think that should be a 5-year felony. I think it should be a civil infraction of $1,000. If the person is doing this to hide a crime, there's a separate law called obstruction of justice. Somebody could, the prosecutor could bring, in addition to an underlying crime, could seek a further penalty for obstruction of justice. So, yeah, it's a felony. So I think we're covered. We're covered there. I mean, this kind of behavior, one way or another, if there's an underlying crime, if there's mutilation, disfigurement, etc., you're talking at least a 5-year felony. But if it's to hide a crime, that's covered by obstruction of justice. So.
I never identified myself, Ben Overdowski for the Office of Legislative Counsel, and the testimony that was had about sort of the genesis of the bill itself is that, so in the case out of Enosburg, which is still ongoing, the prosecutor did not prosecute under the Title 18 statute because they felt like it didn't apply to the situation. So this bill, H41, was introduced to create a crime that could cover the situation of burning a body after it was killed, because those are the allegations of the criminal prosecution right now. It's not really about burying or moving or transporting the body, because if that were the case, they had the statute to prosecute, but it didn't apply based on the prosecutor's discretion. And that was what was testified to in both the House and the Senate.
Zach. So I want to thank Dale for addressing some of the concerns that I think he and I both share. And I guess my question is, if you're looking at section 5211 and you're saying that everything's already been captured in other statutes and other laws, then why do we need this section at all? Like, what is this section accomplishing? That's the point that I'm trying to get to.
Well,
because why not just have carve-outs? Why not just have carve-outs for the funeral homes and whatever else?
So there's a permit requirement, and so for a permit requirement, having a 5-year felony seems wrong. But having some sort of civil fine, that can make sense. Ben.
So just to refresh the committee's recollection from when the bill started here, some of the testimony, I think, in the first time I walked through this bill is that Vermont is one of 2 states that doesn't have a law like this on the books. They don't have a law that addresses necrophilia. We don't have a law that addresses abuse. I won't go into the details of language. You already know about it. And so that was another reason I think that the bill was introduced. That was the testimony, is to fill that gap in a law that Vermont is only one of 2 states in the country that doesn't have a law like this. So a lot of the situations that this bill covers weren't covered.
So I appreciate the context, Ben, but I guess I'm still coming back to, what is section 2 actually going to accomplish?
It criminalizes section 2?
Section 2, not the previous section, which I think everyone's in agreement that this is absolutely
right. So section 2, what that does is changes the criminal felony to a civil penalty.
And so we're only talking about funeral home directors in this instance.
No, it could be anybody. But funeral home directors, from my understanding, one of the examples given in the testimony.
So outside of obstruction of justice, concealing a crime, and other examples, are there instances where someone could be using section 2 as a provision to hide a crime or intent? Because I think that, like, rightfully or wrongly, the concern that many people have brought up, and outside forces have influenced this section, is where.
I'm going to push back on this section in particular. I cannot emphasize enough that it was my understanding when this was voted out of the House, of this committee, by a vote of 11-0-0, that it was intended to be a civil penalty, and I made the mistake of not changing it from a fine to a civil penalty. The term of imprisonment was struck. It was the understanding that I think everybody has testified to today in this committee, So I just want to push back. There was no outside influence
I'm not talking
that
about
I'm aware
influence on
of
you.
on that.
I'm not talking about influence on you. So if I
But
represent,
what I'm saying is that this section,
but I do know that outside
is-
groups, advocacy groups have spoken to senators about this.
well, and that I don't know about, but I'm just saying the
The
language.
idea that they have not influenced is not true. And I keep being challenged on this point. But the fact of the matter is that outside advocacy groups have talked to senators because I had dinner with a bunch of the senators on the judiciary last week and they told me so. So.
But my
The idea that
my
that's
point is
false
not about outside influences. My point is the changes
But I'm
in
not gonna sit
section
here
two
and
that
be
you,
maligned
that
and say
you
that I'm not being
referenced.
truthful about this. I mean, I am representing the facts as I know them. So I'm not gonna be maligned.
And
Not
just-
lying, yeah.
No, and just to be clear, I mean, whatever the Senate did and whatever they heard from downstairs only matters to the extent that we get the language from them. I mean, it's, this is language that is consistent with what we passed out. Whoever talked to the senators, frankly, is not critical, I think, for determining what to do with this. But Tom and then Tom.
Section 2 of this bill. I'm not gonna say outside influences. I'm gonna say Planned Parenthood had nothing to do with the language in section 2. They had zero to do with it. I didn't talk to him about it. Ben obviously didn't talk to him about it. He's admitted the mistake that he made. It would have been in there. And there would have been no question about it. And again, I'm just gonna say it, on section 2, Planned Parenthood had nothing to do about it. Nothing to do with it. I don't know how to make that any clearer. I mean, we can get Planned Parenthood in here to ask them if they had anything to do with the language that we passed out of House Judiciary. And they didn't.
Tom.
So we created a Title 13 criminal statute for all the bad things we can think of to happen to a body or a corpse that we didn't have before.
Correct.
Section 2 in the back. Question is a pre-existing statute that's been in a medical title
Yeah, the public health statutes.
for its existence.
Yeah, I'm not, for a long time.
And we simply struck the 5-year part. Because we separated it, sort of bifurcated the statute a little bit. One is to create the criminal element side and one is to just deal with
Civil penalties.
professional violations.
Mhm. Or in
Or person,
Integrated.
yes,
because you still have the right to take care of your own.
Yeah.
yeah, they're the green burial statutes that provide, which again, I'm not intimately aware of, but they do provide authorization to do a green burial.
Bury your own dead. All right, so I think we've exhausted this, I believe. Unless there's anything else, I would take a motion to concur with page 41 of the Senate proposal of amendment.
So moved.
Is there a second?
Second.
All right, all those in favor, raise your hand. And those opposed, raise your hand. We're missing 911. All right. Thank you for that conversation. And so we'll take a break.
on screen. 11-0.
And Coach, was that a hand for yes or for no? I didn't notice you up there, Coach.
It was in favor,
Okay, all right, thanks.
concurrent.